Hello, classmates. Hello, attorney. So my report for today will be the application, enforcement, and limitations of international human rights law. So there are two prevailing theories in the application of the international human rights law. It's the monist theory and the dualist theory. So for monist theory, it means that the international law and the domestic law comprises of one legal system. Means that the international law is automatically becomes domestic law without the need to enact a separate national law. Domestic laws, including the Constitution that contravene with international law, may be declared invalid. The main advocate for the monist theory was Australian legal scholar Hans Kelsen in the 1920s. So according to Kelsen, the primacy of international law as a derivative of natural law, rather than as merely an expression of individual decisions of the states to be bound through a customary practice. So for Hans Kelsen, the purpose of the international law or the monist theory rather was intended to promote international peace by creating binding obligations enforceable against the state actors in formal international justice institutions as indicated in his framework. So countries that are or that practice monist theory is the Netherlands. They're considered a monist state. And many states are either partly monist or partly dualist. So international states are partly monist and partly dualist as well. So international human rights law dictates domestic laws and the state must enact domestic laws to conform to international laws. But in monist theory, as mentioned, international laws form part of the domestic law. Next, we have the dualist theory. So here, international law and domestic law are different legal systems. International law does not become obligatory to its citizens until the state passes a corresponding domestic law containing its provision. So most of the time, local laws are revisited and amended to conform to international law. So you have to note that until such amendment or ratification, the law the local law remains valid, although this could mean a possible violation of the state of its treaties and obligations. Okay, so the lex posterior principle. So if there are inconsistencies between domestic statutes, treaties, or customary laws, the latter will prevail. So that's applicable for dualist theory. In the Philippines, treaty obligations are usually taken into consideration in the enactment of laws. So, but the Philippine judges would still consider international laws having less binding effect compared to domestic laws. So the Philippines is or adopts the dualist theory. So in order for an international law to be adopted to the Philippines or to form part of the local laws, the Congress has to pass a domestic law in order to enforce international conventions locally. So we have the child abuse law, which is an international law. It was adopted through the Anti-Violence Against Women or the VAUC law, or CEDAW. So how does international law becomes part of the domestic law for dualist theory? So there are two main applications that are being used, the doctrine of transformation and the doctrine of incorporation, which will be later on discussed. So just to give you an idea, the doctrine of incorporation means that generally accepted principles of international law as part of the land. And doctrine of incorporation also indicated in our Constitution through Article 2, Section 2 of the Constitution, which says that Philippine renounces war as an instrument of national policy, adopts the generally accepted principles of international law as part of the law of the land, and adheres to policy of peace, equality, justice, freedom, cooperation, amity with all nations. Okay, so in so far as the international laws concerned, the doctrine of incorporation is primarily applied in Article 2, Section 2 of the Constitution. So just to give us a review on the difference of the monist and dualist theory. So in monist theory, international and national laws belong to one system of law, while dualist, international does not become obligatory to its citizens until state passes a corresponding domestic law. International law is superior to domestic law, while when international or national law are in conflict, national law must prevail. So it says here that in monastery, it prioritizes the desirability of a formal international legal order to establish a rule of law among nations, while dualist theory prioritizes the notions of individual self-determination and sovereignty at the state level. International law serves not merely as a legal framework to guide the state and its relations in the international sphere, but as a source of law integrated into the superior domestic law. While in dualist theory, in order for an international law to be binding at the domestic level and enforceable in domestic court, the treaty must be specifically implemented through an appropriate legal or legislation. Okay. Now we go back to the doctrine of incorporation. So, to give you an idea, there is a case, the Tanyada versus Angara. This is one of the famous cases that um, elaborates the doctrine of incorporation. So, to just give you an overview on the facts of the case, so it was a petition to nullify the Philippine ratification of the World Trade Organization. Um, and the World Trade Organization opens access to foreign markets, especially its major trading partners. So the contention was the petitioners view the World Trade Agreement um, as a limiting or as an impairment for the Philippine economic sovereignty and legislative power, and that the policy of Filipino first should come. However, the court held that or the court explained that the doctrine of incorporation, by doctrine of incorporation, the country is bound by generally accepted principles of international law, which are considered to be automatically part of our own laws. So under this, the rules of international law form part of the law of the land, and no further legislation or action is needed to make such rules applicable in the domestic spheres. So it means that the rules of international law form part of the law of the land. Hence, no legislative action is required to make them applicable. So by doctrine of incorporation, the Philippines already generally accepts the principles of international law. Right, so that means that we have to adapt the open or the international market as well. Because I believe in this case, it didn't, the Filipino first policy was explained that shouldn't be taken literally, but rather it doesn't limit the Philippines to just put the Filipino first, or it doesn't limit the Philippines to live in like its own world, but to also open up to trades internationally. Now we go to the doctrine of transformation. So it must be expressly and specifically transformed into domestic law through appropriate constitutional machinery such as the Congress or the Parliament. So treaties do not form part of the law unless a statute is being implemented or a local statute is being implemented. Okay, so in the Constitution, Article 7, Section 21, it says there, no treaty or international agreement shall be valid and effective unless concurred in by the least 2/3 of all the members of the Senate. So just to give us an idea for a case that also where the court explained the doctrine of transformation is the Pharmaceutical and Healthcare Association versus the Secretary of Health Duque. So to give us an overview, the facts of the case states that the Pharmaceutical and Healthcare Association of the Philippines sought to nullify Administrative Order 2006-012 or the revised implementing rules and regulations of the Milk Code. So not the Milk Code not only the Milk Code, but also various international agreements and instruments regarding infant and young child nutrition. So the Milk Code is an international code of marketing of breast milk substitutes adopted by the World Health Assembly. Okay, so with this, the issue was whether or not international agreement, as mentioned in the case, are part of the law of the land, um, if the Milk Code would be implemented in the Philippines, or should it be adopted by the Philippines as it is. So the court held that treaties or conventional international law must go through a process prescribed by the Constitution for it to be transformed into municipal law that can be applied to domestic conflicts. So the Milk Code adopted most of the provisions from the ICMBS and the World Health Association resolutions, which includes the non-promotion or advertisement of breast milk substitute. So it has have not been adopted as a domestic law, and it cannot be considered as part of the law of the land. Further, the WHA resolutions cannot be considered as the customary international law. Okay, so as mentioned again, the consent of the state to be bound by a treaty may be expressed by signature, exchange of instrument constituting a treaty, ratification, acceptance, approval, or accession, or by any other means, if so agreed. Okay, so what is a signature? So signature is a treaty. However, it does not automatically mean consent of a state to be bound by a said treaty. If under the national law, it is the act of ratification which operates the bind to the state. So there still must be a process of ratification, acceptance, or approval to be done by the state. So without ratification, the signature may only operate as a means of authentication and to show the openness of the signatory state for further discussion on the treaty making process. Okay, so signature ad referendum. So the signature becomes definitive only once the signature is confirmed by the state. So when we say definitive signature, it operates as the consent of the state to be bound by a treaty when the treaty is not subject to ratification, acceptance, or approval. In the case Pimentel versus Executive Secretary, it was underscored that the signing of a treaty and the ratification are two separate and distinct steps in treaty-making process. As earlier discussed, the signature is primarily intended as a means of authenticating the instrument and as a symbol of good faith of the parties. It is usually performed by the state's authorized representative in the diplomatic mission. Exchange of letters or notes. What do we mean by this? So exchange of a letter or notes means that consent can be expressed through exchange of letters or notes. So here there will be two letters if the treaty is bilateral and one with at least one from each party. So this is a routine agreement and there's an exchange of two documents, each for party being in the possession of one, signed by the representative of the other. Okay, so in addition, of exchange of notes means that the agreement consists of two documents of each parties, and under this procedure, the accepting state repeats the text of the offering state to record its assent. So the signatories of the letters may be government ministers, diplomats, department heads, and the technique of exchanging notes is frequently resorted to either because it's speedy procedure or sometimes to avoid the process of legislative approval. So literally exchanging notes or the exchange of the treaty. So when we say an act of formal confirmation, it is where an international organization that intends to be bound by a treaty. Instead of ratification, the term used is act of formal confirmation. So the state parties may be allowed to limit, restrict, or modify the application of a treaty by the following processes: reservation and interpretative declaration. Okay, so reservation enables a state to accept a multilateral treaty as a whole by giving it the possibility not to apply certain provision with which it does not want to comply. Interpretative declaration is whereby the state or the organization purports to specify or clarify the meaning or scope of a treaty or of a certain provision. Okay. Another one is through modification. Modification refers to the variation of a certain treaty provisions only as between particular parties of a treaty, while in their relation to other parties and the original treaty previously remains applicable. Another one is the denunciation, a unilateral act by which a party seeks to terminate its participation in a treaty. So it is important to note that a state may not invoke the provision of its international law as justification for its failure to perform a treaty. Okay. To elaborate further, when we say reservation, it is a unilateral statement, however phrased or named, it is made by the state when signing, ratifying, accepting, approving, or ascending to a treaty, whereby it purports to exclude or to modify the legal effect of certain provisions of the treaty in their application to the state. So when is reservation allowed or not allowed rather? When it is prohibited by the treaty, when it is not included in the reservation specified by the treaty, and it is compatible with the object and purpose of the treaty. A signatory or contracting state may object to a reservation if it believes that it is compatible with the object and the purpose of the treaty. Okay. So interpretative declaration is an instrument that is annexed to a treaty with the goal of interpreting or explaining the provisions of the latter. So unilateral statements, however phrased or named, made by the state or an international organization, whereby the state or the organization purports to specify or clarify the meaning of the scope of a treaty of a certain or of certain of its provision. So modifications is a variation of certain treaty provisions only as far between particular parties of a treaty. So their relation to the other party, the original treaty's provision remain applicable. So if the treaty is silent on modifications, they are allowed only if the modifications do not affect the rights or obligations of the parties to the treaty and do not contravene the object or purpose of the treaty. Again, denunciation is the withdrawal by the state party from a treaty. So treaties such as the CRC, IHRL, or COT allowed denunciation. So a party seeks to terminate the participation of a treaty. So that's basically a denunciation. And additionally, for denunciation, it should be a unilateral act by which the party seeks to terminate its participation. Okay, so we go to the enforcement mechanisms of treaty. So enforcement mechanisms are in place for violators such as the state, individuals, juridical persons, groups, and business entities. So there's a different enforcement mechanism involved for the enforcement of human rights law against individual violators and enforcement against state violators. So domestic enforcement In order to effectively protect its individuals from infringement on their human rights, enforcement at national law is necessary and desirable. So we have the most domestic enforcements. We can be found on the revised penal code, a new civil code, the revised administrative code, and the protective writs and similar juridical or judicial remedies. For the international enforcement of human rights or international human rights, individuals may be brought to justice before a hybrid courts, ad hoc international courts, or before the ICC. In the latter court, however, its jurisdiction is limited to crimes of genocide, crimes against humanity, war crimes, and crimes against or crimes of aggression. So for court of action, where the violator is a state, redress may be sought at the national, regional, or international courts. In the regional level, regional human rights conventions or treaties govern the manner by which human rights commission and courts may be assessed to seek redress. So for diplomatic means, aside from bringing complaints before human rights courts, states whose national laws have victims or have been victims of human rights violation by another state may opt to avail of diplomatic means. So this may entail negotiations and dialogues. So for retortion, this may involve withholding of foreign assistance or stoppage of oil imports. So these are unfriendly acts which do not necessarily constitute violation of rights of the offending state. For example, if for US they may, or for oil producing countries, they may withhold to supply the country through the action of retortion. So for countermeasures are the response by the state to the wrongful conduct of another as a tool of self-redress. For military intervention, so the use of armed forces is still being resorted nowadays. The military intervention in Libya in 2011 was by virtue of a United Nations resolution. So the use of force in Iraq, however, did not have such authority. I believe in Libya there was a civil war. So for restrictions and limitations. So the substance of human rights cannot be taken away from human beings. Its exercise may, however, be regulated. So as an unrestricted exercise of rights could infringe on the rights of others or could be detrimental to public health, public morals, and national security. States do not have absolute discretion and prerogative to restrict the exercise of human rights. What are the parameters to restrict the exercise of human rights? So there must be a clear legal provision of law. The restriction must be a specific legitimate purpose. The proportionality test must be applied. The least intrusive measure should be applied, and the laws must be strictly interpreted against restrictions. So if you analyze this, it's also similar to um, the, the, the germane purposes of the police power, right? Okay. So derogation. So some human rights are non-derogable and some may be suspended or restricted by the states. So Article 4 of the ICCPR allows the derogation of rights provided that there is a public emergency where threatens the life of the nation. There's an existence of public emergency is officially proclaimed. The derogation is to extent strictly required by exigence of the situation, and the measures taken are not inconsistent with the state's other obligations under international law, and the measures taken do not involve discrimination solely on the ground of race, color, sex, language, religion, or social origin. Okay, so that ends my report. Thank you.